Constitution by purporting to take away the mandate of the IEBC, an independent body under the Constitution. Further, it was contended that the second schedule impermissibly directed IEBC on the execution of its constitutional functions. It is imperative to begin the analysis on the constitutionality of the second schedule of the amendment bill by pointing out that given my earlier finding that the basic structure and doctrine does not apply under the Constitution of Kenya 2010, my determination of this question rests on the procedural concerns linked to whether there was public participation in coming up with the second schedule. This is because the provisions of Article 89 are amendable as long as due process is followed. It ought to be appreciated that amendments touching on matters falling within the remit of Article 255(1), which are the core fundamental commitments of the Constitution, ought to be undertaken through a highly participatory and inclusive process. It should be noted that directly allocating and apportioning constituencies usurps the mandate of IEBC, an independent constitution commission, removing the possibility of judicial review of the delimitation as an effect on the independence of the judiciary. The centrality of the constituencies as units of political representation in the National Assembly means that they ought to be apportioned and allocated by a neutral and professional actor, much more so because malapportioned constituencies have the potential of diluting the power of the votes, hence threatening the animating goal of fair and effective representation, which is at the heart of the foundational value of democratic governance enshrined in Article 4.2 and 10.2a of the Constitution. Further, since the constituencies are units of social and economic development through allocation of national government constituency development fund and the recruitment into disciplined forces such as the Kenyan Defence Forces and the National Police Service, the delimitation of constituencies has implications on the constitutional values and principles of equity and social justice enshrined in Article 10.2b of the Constitution. It goes therefore without saying that the delimitation of constituencies must be accompanied by a process that is fair and just, which is the golden thread that runs through our constitutional order as elaborated in the preceding chapters. I've also considered that this process was not subjected to public participation and referred to cases by this court, the British American Tobacco case, that provided that the tests for adequate public participation should be reasonableness. That should be the threshold. Following from this case, I now examine whether there was reasonable notice and opportunity afforded to the public for generating the views and deliberating on apportioning and allocating the disputed 70 constituencies as provided for in the schedule. An examination of the process leading to the BBI task force and the BBI steering committee reflects that there was reasonable participation and involvement of the people in coming up with the recommendations of the bill that was published on 21st October 2020. There is, however, no evidence of any form of public participation or deliberation between 21st October 2020 and 25th November 2020 when changes to the draft constitution of Kenyan bill was made, including the addition of the second schedule. This leads, therefore, to my conclusion that the constitutional threshold of reasonable public participation was not met when the second schedule of the amendment bill was presented. Consequently, I come to the conclusion that the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Article 10(2) of the Constitution. I move now to the fourth issue on the presidential immunity. At the outset, it is important to point out that given the Court of Appeal held that the President was not served with the petition number E400 of 2020, in the proceedings before the High Court in which this question arose, it was improper for the Court of Appeal to proceed and adjudicate the question of interpretation of Article 143(2) of the Constitution. However, as conceded in the President's written submissions filed before the High Court, there is a public element in this matter, so this court should clarify and settle the law on the nature and scope of protection of the President from civil legal proceedings, considering the findings of the two courts below. It is generally recognized that immunity from legal proceedings usually takes two forms. First, immunity from liability protects officials not from proceedings being undertaken, but from personal liability at the end of the proceedings, which relates to enforcement. Second, immunity from proceedings is a broader form of immunity that overthrows the court's or tribunal's jurisdiction to hear a matter because the parties against whom the proceedings are undertaken enjoys immunity. Further, there is absolute and qualified immunity. Absolute immunity has no limitation as to its application, while qualified immunity usually has limitation, like extent of actions and other related to other official function, whether done lawfully or done in good faith. The Constitution contemplates immunity of certain officials in the performance of their functions. For example, Article 160, a member of the judiciary; Article 250, a member of the commission; Article 143, criminal proceedings shall not be instituted against the President or a person performing the functions of that office during the tenure. From the structural ending of the above provisions, there are glaring distinctions that illuminate the nature and scope of presidential immunity envisaged under Article 143(2) of the Constitution. Firstly, all the officials set out above enjoy immunity as persons, holder of office or member of a commission, but not their offices, whereas the President enjoys immunity as both the person in the office and the office itself. This is evident from the choice of phraseology used in Article 143 to the effect that the President or the person performing the functions. To make the point clearer, one can contrast the nature of immunity envisaged in Article 143(2) to Article 259 for an holder of an independent office. Consequently, this brings me to the inescapable conclusion that the immunity of the President is unlike that of the other state actors. The President not only enjoys functional immunity like all public officials who perform state duties, which protects them from civil liability for official functions, they further enjoy sovereign immunity as the end of state and the single representation of the sovereignty of the Republic. Indeed, it is only sovereign immunity that can immunize anyone against both proceedings and criminal liability, because any other immunity would be related to official functions and therefore would inherently be a qualified immunity. The two courts below, especially majority opinion of the Court of Appeal, relied on the phrase "in the exercise of their powers under this Constitution." I am conscious that part of the President's role in the performance of their functions is the interpretation of the Constitution as to whether or not it gives them power to perform particular roles. Upon such interpretation, the President either acts or fails to act in the belief that either that power exists or does not exist. It will follow then that if proceedings were to be instituted against the President after the interpretation which is considered to have been wrong interpretation, then such proceedings should fall within the immunity contemplated in Article 143(2), in that it will be within the performance of the President's functions. There is no provision allowing or requiring the President to seek an advisory opinion from the judiciary before exercising their duties or before determining whether they have power to perform any official acts. And in any event, this would generally bar the separation of power. Further, the two superior courts held that the President or the person performing the functions of the President is not above the law and should be amenable to the law if they act against the Constitution. The implication of this finding is far-reaching and therefore calls for a very careful analysis and consideration by this court. It is necessary to state that the Constitution has provided for how the President and the Executive in general can be kept in check through political accountability, with the provision that the President is liable for impeachment under Article 145 of the Constitution. The grounds for impeachment listed under Article 145(1) of the Constitution includes gross violation of the Constitution or any other law, commission of a crime under national or international law, or gross misconduct. This means that there is a clear avenue to check the President's conduct as acknowledged by this court, by the Court of Appeal in the case of Minister for Internal Security and Provincial Administration versus Center for Rights, Education and Awareness. With respect to legal accountability, the protection of the President from legal proceedings under Article 143 does not mean that President's actions or omissions cannot be challenged in court. Anybody or a party aggrieved by the President's actions or failure can initiate proceedings against the Attorney General, whom by virtue of being the legal representative of the government in legal proceedings also represents the President. As such, pursuant to Article 156(4) of the Constitution, the exercise of public power by the President can be challenged in court of law by suing the Attorney General through an action of judicial review or constitutional petition, wherein a court may issue appropriate remedies. In effect, the findings of the two superior courts and the ramification of rendering Article 143(2) of the Constitution ineffective or superfluous. This is an interpretive path that, in my view, is not open to the courts. An interpretation of the Constitution that resorts to an amendment by a judgment is tantamount to judicial overreach. This leads me to the conclusion that the learned judges unfortunately fell in error in their interpretation and application of Article 143(2) of the Constitution by holding that civil proceedings can be instituted against the President or a person performing the functions of the President during the tenure of the office. I hold that civil proceedings cannot be instituted against the President or a person performing the functions of the President of the office of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Such proceedings can be instituted against the President via the Attorney General. Issue number 5 on public participation, whether there was public participation. The issue was framed by the court with two components. The first relates to the role of IBC and Article 257(4), whether IBC is under an obligation to ascertain that promoters of a popular initiative have undertaken public participation during the collection of signatures. It is clear to me that there is no direct requirement arising from the provision of Article 257(4) that imposes an obligation on IEBC to ascertain that the promoters of the popular initiative have undertaken public participation. Nonetheless, the High Court held that IEBC was obligated to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation as provided for under Article 10(1) of the Constitution. It is necessary to keep in mind, to keep reminding ourselves that IEBC, being a creature of the Constitution and statute, can only discharge a mandate vested in it explicitly by the law. This is a direction given under Article 10, which identifies the rule of law as the national value and the principle of governance. It follows that IEBC, like all other public bodies, cannot by craft or innovation or interpretation extend its power to include ascertaining whether a promoter or a popular initiator has complied with the public participation requirements under the Constitution. Equally, courts should not encourage extension of powers by constitutional or statutory bodies. Such bodies must operate strictly within the four corners of their constitutional and statutory mandates. Given this view, unless there is a statutory framework enacted that confers power on IEBC to ascertain whether a promoter has undertaken public participation, the exercise of such a mandate would be a mere overreach. In the upshot, therefore, it is my finding on the first part of the question as framed that there was no obligation on IEBC to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation before determining that the amendment bill had met the constitutional requirements for transmittal to the county assemblies. As regards the second part of the question as framed relates to whether there was public participation in respect to the amendment bill. In determining this question, it ought to be appreciated that while participation of the people has been identified as foundational value and principle of governance under Article 10(2), it is even more crucial with regard to processes that would lead to constitutional amendments. This is so because it is the people's acceptance and ownership that grants democratic legitimacy and authority to the Constitution. It is against the standards that are set in the case of BAT by this court that I proceeded to examine whether there was public participation as regards the Constitutional Amendment Bill 2020. From the provisions of Article 257, it is discernible that there are 4 stages in the amendment process under the popular initiative route. The initiation stage, that is the correction of signatures, which typically involves the promoters of the initiative setting the referendum agenda. However, this is to be within the context of the constitutionally guaranteed opportunities for citizens to influence the process. It is also not lost to me that an onerous requirement that a promoter conducts public participation before presenting signatures for verification at this stage would be unreasonable, because the whole process may be rejected by IEBC like it did the 2 popular initiatives dubbed Okoa Kenya and Punguza Mizigo. Moreover, unlike subsequent stages where the cost of public participation is borne by the public bodies, that is the county assemblies, the IEBC, the cost of public participation will be borne by citizens or a group of citizens. In such a context, I'm of the view that the requirement of public participation during the period proceeding and during the collection of signature under the popular initiative process should not impose onerous requirements on a promoter of the initiative. The second stage, which is the assembly stage, seems to lend itself more to public participation. This is because the Constitution imposes a normative obligation for the public participation in legislative affairs. Moreover, a timeline of 3 months within which county assemblies ought to consider the bill of the constitutional amendment supports a reading that assemblies must solicit for input from the public. The third stage, that is passage through the Houses of Parliament, is another key stage for public participation. The fourth, the referendum stage, is intended to serve as a national deliberative moment. Hence, duty bearers, including IBC, have an obligation to facilitate a broad participatory process that includes voter education. It is important to reiterate that the requisite mode, degree, scope, and extent of public participation, or sufficiency thereof, is to be determined based on the peculiar circumstances of each case. Nonetheless, public participation must not be an illusion, but a meaningful engagement. On the question of whether there was reasonable public participation and the question of burden of proof, Okwengu and Kiagi JJA held the view, and rightly so, that by dint of Section 112 of the Evidence Act, once there is an allegation of lack of public participation, the burden shifts to the person charged with the responsibility of performing the same to establish adequate participation. However, Tuyot J.A. arrived at a slightly different conclusion. In his view, the burden could only shift to the promoters of the amendment bill if there was evidence to the effect that the persons or person who appended their signature in the support of the bill were not aware of the amendment bill. The evidence before the court shows there was a reasonable attempt at public participation with respect to the impugned initiative. This view is supported by the evidence of Dennis Waweru, co-chairperson of the BBI National Secretariat, in his affidavit sworn on February 2022, which was in response to petition number 416 of 2020 by Morara Omoke. He reports that BBI Task Force Steering Committee and the amendment bill were products of comprehensive consultative public engagement all over the Republic, which process entailed voluntary nationwide public participation. In addition, he annexed to his affidavit invitations, deliberations, reports, and memoranda to that effect. I have also taken time to go through the BBI Steering Committee report, and there is evidence of public participation with regard to the process as documented on page 2 of the report, which I have reproduced in my judgment. There was no challenge to the contents of the BBI Steering Committee report and the deposition by Dennis Waweru, which therefore leads to an unavoidable conclusion that there was reasonable public participation with respect to the amendment bill, save for the second schedule thereto. As far as the second schedule of the amendment bill is concerned, as I have discussed earlier, it was a late addition to the process. It is worth reiterating that the evidence of public participation runs up to the launch of the Steering Committee report that took place on 21st October 2020, wherein the draft amendment bill was attached and unveiled to the public. This version did not have the second schedule in question. There is no evidence of public participation between 21st October 2020 and 25th of November 2020, when the amendment bill was published and introduced in the second schedule for the first time. Having made the above findings, I need to point out in obiter that there is need for Parliament to enact a legislative framework to guide and regulate the process of public participation. While the Constitution sets a broad normative obligation for public participation in various governance processes, there is no legislative framework regulating how this obligation ought to be implemented. It is instructive to note that there have been 3 bills tabled in the Houses of Parliament with respect to providing a legal framework, but none of them have been successful. It ought to be appreciated that legislature has a duty to fulfill its obligation under the Constitution by enacting roles to actualize constitutional imperatives. In the end, I owned that there was reasonable public participation with respect to the amendment bill, save for the second schedule of the impugned bill. I now move to issue number 6, the composition and quorum of IEBC. The above issue was raised in the High Court, bind petition number 416 of 2020. It was arranged that IEBC lacked quorum for consideration and approval of policy matters relating to conduct of referenda, including verification of signatures under Article 257(4). As at the time the verification process was undertaken, only 3 commissioners of IEBC were in office, while 4 commissioners had resigned and they had not been replaced. The High Court was persuaded by the petitioners in the aforementioned case and held that the requisite quorum for purposes of carrying out its business, as well as the verification of the signatures, was lacking. The position was affirmed by a majority of the Court of Appeal bench, with Sishar and JEN dissenting. In light of this background, that this court is called upon to determine whether IEBC was constitutionally infirm in terms of its composition. It ought to be appreciated that the legal regime on the composition of IEBC is regulated by the Constitution. While Article 88 of the Constitution establishes IEBC, provides for eligibility of appointment of its members and its mandates, this provision does not touch on its composition. It is Article 251 which provides for the composition of the commissions and independent offices. Article 248, 2C lists IEBC as one of the commissions and independent offices, making Article 251 the constitutional provision regulating its composition. The Article 251 provides as follows, I quote, "Each commission shall consist of at least 3, but not more than 9 members." Section 5(1) of the IEBC Act, which statute, according to its long title, is an act of Parliament to make a provision for the appointment, effective operation of the IEBC, provided that the commission shall consist of a chairperson and 6 other members appointed in accordance with Article 254 of the Constitution. Section 5(1) appears to have influenced the reasons of the 2 courts below as regards the quorum. It is readily apparent that there is a possibility of the provisions of Article 250 of the Constitution and Section 5(1) of the IEBC Act being read as imposing different requirements with regard to the composition of IEBC. This leads to the question as to whether IEBC, composed of 3 commissioners, would be infirm to conduct its constitutional mandate, including the verification process provided for under Article 257. My finding on the above question is that Section 5(1) of the IEBC Act should be read in a manner that conforms to Article 251 of the Constitution. The reason being that Article 2, which expresses the supremacy of the Constitution, demands that no legal norm, including registration, should have an effect contrary to that expressed in the Constitution. In other words, the provisions of the Act of Parliament cannot erode the Constitution. The expressed intention of Parliament in registration cannot trump the normative command of the Constitution in a legal system where the Constitution is supreme. And this has been emphasized by the decision of this court in the case of Hassan Joho and also in the case of Mumo Matemo. I have also looked at persuasive jurisprudence from other courts in other jurisdictions which support this approach to statutory interpretation. Therefore, the implication is that IEBC is legally constituted when composed of the minimum number of 3 commissioners stipulated in Article 251 of the Constitution. As such, I find IEBC was constitutionally and legally composed when it undertook the verification of the verification process under Article 257 of the Constitution. This now takes me to the last issue. Issue number 7. On this issue, the High Court determined that Article 257(10) of the Constitution requires all specific proposed amendments to be submitted as separate and distinct referendum questions to the people in a referendum ballot paper, which are to be voted for separately and distinctively. This finding was affirmed by Nambuye, Okwengu, Kiagi, Katembo, JA, and a qualifier subject to the nature of the proposed amendments. Musinga JA disagreed with the learned judges of the High Court and they held that what is to be subjected to the referendum is an amendment bill which the people are to approve or disapprove. On its part, Tuyot JA held that since IBC had not received the requisites and are not discharged its responsibility of framing the questions, the matter was not ripe for determination. The first question for determination is a preliminary one, which is whether the question on formulation of referendum question was ripe for determination. The doctrine of ripeness focuses on when a dispute has matured. It prevents parties from approaching a court before a party has been subjected to any prejudice or real threat of prejudice as a result of a registration or conduct that is challenged. At the time of filing of the subject petitions, particularly petition E400 of 2020, the amendment bill was yet to be subjected to the county assemblies for debate. This means that IBC was yet to be invited to make a determination on the manner and form of the referendum questions, taking into consideration that IBC obligation under Article 257(10) of the Constitution had not arisen. Tuyot JA was right in finding that there was no live controversy before the High Court, which ought to have declined to make a determination on this case. Accordingly, I find that the issue of whether Article 277(10) of the Constitution entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. On the issue of costs, this being a public interest matter, I also find that each party, like it was found in the courts below, should bear their own costs. My findings, therefore, are number 1, the basic structure doctrine and the 4 sequential steps for amendment as prescribed by the 2 superior courts below are not applicable in Kenya under the Constitution of Kenya 2010. Number 2, the President is not permitted to initiate constitutional amendments or changes through a popular initiative route provided under Article 257 of the Constitution. That being the case, the Constitution bill does not pass muster as a popular initiative under the provisions of Article 257 of the Constitution. 3, the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Articles 10(2)A and 87 89(7)(a) of the Constitution. 4, civil proceedings cannot be instituted in any court against the President or the person performing the functions of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Issue number 5, there was no obligation on IEBC to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation before determining the amendment bill. In addition, there was public participation with respect to the amendment bill, save with respect to the second schedule of the impugned bill. Issue number 6, IEBC and the requisite quorum to undertake the verification of signatures in support of the amendment bill and Article 257(4) of the Constitution. 7, I find the question raised regarding the interpretation of Article 257(10) of the Constitution on whether or not it entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. And lastly, on cost, this being a public interest